All right. Good morning again, everyone. Ms. Rivers, are you able to hear us?
Good morning, Judge. Yes, I am. I'm ready to hear you. I'm ready to go.
Fantastic. We've got a status conference calendar. The purpose of the status conferences is to make sure there are no discovery issues. If your case is on this calendar, there have been no evidentiary motions filed, or if they were, they've been resolved. So then I just need to make sure we can move the case to a trial calendar. So we'll work through that and see where we're going with these 10 cases. Position 1 is State versus Travarius Evans.
Good morning, Your Honor. This is Mr. Evans here in the middle.
Evans is here. Great. Mr. Evans, if you'd come sit with Ms. Feely, please. This is an old case, 18 SC 160079. Ms. Feely represents Mr. Evans, who's here in court. Mr. Thomas, your case?
That's correct, Your Honor.
Excellent. Ms. Feely, tell me what the discovery situation is in the case.
This isn't a super complicated case, so there isn't much, but I don't think there would be. So I think I do have everything. And my discussions with Mr. Evans, I think we would be ready to, when reached, to be on a trial calendar.
Okay. And you don't see any reason for any late motions. I say late, not because they'd be late from you, but your predecessor had the case for a while and there aren't motions to work through.
Nothing that I flagged, Your Honor.
Okay. Mr. Thomas, any discovery or other progress related issues that would prevent this case from being added to a trial calendar?
Nothing right now, Your Honor, and I will communicate an offer to the defendant, Ms. Feely, within 7 days.
Okay, great. Ms. Feely, if this is a matter that is going to work out short of trial, the sooner we can do that for Mr. Evans and the alleged victim, the better. So we can move forward. Otherwise, we'll get it on a trial calendar. Let me check a couple things with the case.
And Your Honor, I just wanted to say for the record, as far as discovery, there is no 911 CAD or body cam for this. So if you're looking on some that, you just don't have it. So I just want to make sure that's clear.
Okay. This is a strange docket. There's no bond order. There's an indictment in June of 2018, and they went into judicial hold, and then it's just here. So I don't know. This is the smallest docket. There's like 10 entries in the docket. Time to get it to trial. All right. We will do that. Mr. Evans, do you have any questions?
Not as of now.
Okay. 99% of your questions will go to Ms. Feely. But if you had any procedural questions, like, hey, what's going on with my case? I'm happy to talk about that now. I don't know why your case reached the age that it did. There's this 2-year gap in the case file. A warrant was issued in May of 2019. Doesn't say what happened with that warrant. I assume it was a warrant because you supposedly didn't come to court. It got lifted and here we are. So just make sure you keep coming to court. Did you get something in the mail telling you had court today?
Yes, I did.
Good. The address we've got in the system for you is a Chimney Oaks address. Still good for you?
Yes, sir.
Great. If it changes, let Ms. Feely know so she can get it changed in the system, because that's where we'll be pushing out the notices.
Okay.
All right. We're good. We'll get it on a trial calendar this summer sometime. If there's nothing else, Ms. Feely, for Mr. Evans, he's free to go. Next up is Anthony Johnson.
This is my case. I haven't actually met Mr. Johnson in person. However, I have spoken with him over the phone. But I don't know if I expected him on Zoom this morning.
There is one phone number only, so I don't know if that's Mr. Johnson. Everyone else has got a name and it's not Anthony or Johnson. He's not here, but if you want, when you get a break, to reach out to him, figure out what his situation is.
So there is somebody on Zoom under REVVL. It looks like he's muted, but it looks like he's trying to talk.
Oh, there's another one. You're right.
Johnson.
Oh, okay. Look at that. Good catch.
Turn your microphones on, please.
Yeah, please have the microphones on both. Don't turn them off. Ms. Charles loves turning hers off. Have it be green all the time, unless there's some top secret conversation you're having, in which case go into the jury room. Thank you. We got to get Mr. Johnson figuring out how to turn on his microphone. But can you hear me, Mr. Johnson? Raise your hand if you can hear me. Excellent. We're going to have the conversation. If there's something we really, really need to hear from you, maybe you can send a text to your lawyer. But I think we can have this conversation with you hearing us, but us not hearing you. All right. So let's have the status conference in position 2. It's 21 SC 178145, State versus Anthony Johnson. Mr. Johnson is online. I can see him. He has made clear he can hear us. His lawyer is Ms. Feely, who is here in court. And let's talk about where you are with discovery, Ms. Feely.
I think I have everything. I have medical records that appear to be complete, and everything else I think looks in good shape. I do need an offer to discuss with Mr. Johnson, but I think this is in a position that can move forward.
Okay. Sounds like in 7 days, you'll get an offer from Mr. Thomas. On a going forward basis, since you get these calendars more than 7 days in advance of the hearing, an offer beforehand is great, because if these defendants wanted to resolve their case by way of plea and want to be able to withdraw their plea if they weren't happy with their sentence, today is the day to do that, or before today. So I'm still happy to take a plea. It'll just be a slightly different structure. So it sounds like discovery is good. There are no motions in the docket. So we ought to be able, just like Mr. Evans's case, to move this to a trial calendar so that we keep it going. Mr. Thomas, anything from the state in Mr. Johnson's case?
Nothing from the state, Your Honor.
Pardon me?
Nothing from the state.
Okay. Mr. Johnson, your bond requires that you live at Childs Drive. Do you still live there?
Yes, sir. Can you hear me?
Oh, yeah, you're live. Excellent. You found the unmute button.
Yes, sir. Your Honor, I still live there. And once you're finished, I'd like to address you. There's a lot of issues going on with my case that you're not aware of.
Okay, well, we can talk in just a second. I just want to make sure you're still at that address, because that's a condition of your bond. In fact, you're supposed to stay there unless you're going to work or court, church, doctor, and you're staying away from Mr. Funderburk. All
Yes,
correct?
Yes, sir.
Excellent. Okay. We can talk about your case. My advice to you is that you don't start talking about the facts of your case. If you want to talk about process, we should do that. But if you want to let me know, hey, Mr. Funderburk is full of baloney, now's not the time for that. And Ms. Feely will probably figure out a way to mute you so that we don't get into the facts and substance of your case. With that admonition, what is it that you wanted to talk about?
I wanted to talk about the conduct of my attorney that was prior on my case, Ms. Patel. The state bar rules of professional standards and conduct, she violated so many. She would have information from me about my case. She blatantly came to the court and lied to you several times, telling you that I didn't have a proper address to go to, which caused me to be incarcerated for an additional almost 6 months. When I have recordings of the people that she talked to, how she called and actually, and I spoke with, if you noticed, the last time I was in court, her supervisor came and represented me that time to get me the bond. This was because she had sit back and came to court several times and told you lies that she hadn't spoken with anyone, and everyone that she had spoken with, or two people she spoken with, said that it was not okay for them to actually let me, bond out to their house, but that wasn't the case. I even have one guy who has recording on her actual assistants coming out and speaking with him for almost an hour and a half. Even the supervisor at that time sit there and lied to you and told you that she had spoke with the Mr. Alberto, which I'm living with right now. He's the one that has the recording of her supervisor over the phone. She told you it was over the phone, but her assistant came in and spoke with Mr. Alberto for over an hour. She withheld information about my case. She also refused to give me a discovery package. She came out to the jail and spoke to me once. And once I found out, she was actually calling the people that were telling me, that I was telling her would let me bond out to the house, telling them that the court would be sending police out to the house at any time. They would be subject to drug screen, all these things. I made all these things, known to her supervisor, and her supervisor tried to call and smooth things over after I got out. And then she quits the office. She quits the job. I was planning on filing a grievance against her with the bar. I let them know all the information that I have, everything she's done. And she and her assistant was actually there at the jail when she withheld information. I've been out all this time. I haven't received the discovery package, which I'm supposed to get within 30 days of being, actually indicted. I have yet to be able to contact anyone. The first time I spoke with this attorney that I have right now, which was yesterday, right? One day prior to me coming to court, I haven't received anything in the mail whatsoever. She was refusing to take my phone calls as I called her. I called her supervisor. We spoke twice, and she was going to try, she said, to do something to rectify the matter. And now here it is. If you look, I know you understand all the rules of, professional standards and conduct, and I know you understand everything that's going on with the law. I can't have, this is my life. I have a surgery in which I have to get my 5th and 6th vertebrae removed. I'm almost paralyzed. I've been incarcerated for 8 months due to no other reason than Ms. Patel totally not, doing her job and actually misleading the court. Now, the law states that if I can't get proper representation from, the people at the public defender's office at the court should hire me a private attorney. And I would definitely, strongly advocate for you doing that, because if I could sit back and just show you all the things that she's done dealing with my case, it's horrific. And I have no confidence, in getting proper representation. I can't speak against the attorney I have now because she hasn't done anything to me. I just speak about what's been done as of far. Your Honor, I broke my wrist the first day I was in jail, wound up staying in there this 8 months, because my attorney was lying to the court, and I can prove all and everything I'm saying.
All right, I'm going to talk for a little bit now. Okay, I appreciate you sharing that. I now understand much better your frustration with Ms. Patel. As you've noted, Ms. Patel's not on your case anymore. She's not with the public defender's office anymore. Ms. Feely, who called you yesterday, it sounds like, and who is here in court, is the senior public defender who's assigned to your case now. I appreciate an important thing you said, that you're not saying anything about Ms. Feely yet because you haven't had a chance to get to know her and see if she's in a position to address some of the very valid concerns you have. Where's my discovery? Could we talk about the case? Things like that. So my request to you is that you give Ms. Feely a chance. If that's a situation that doesn't work for you, you can let me know that. I couldn't quite make out what you said about your right to another attorney. I can, if I think your inability to work with Ms. Feely, and don't take that the wrong way. I'm not saying it's you. I'm not saying it's Ms. Feely, but if you and Ms. Feely cannot develop a meaningful working relationship, I am able to appoint someone else. I don't get you a private attorney. You would go to the conflict defender, who handles cases when either there are two defendants, because the public defender can only represent one defendant in a case, or, as the name suggests, conflict. If a conflict develops for some other reason, the public defender can't take the case, it goes to the conflict defender. And we've got one of those. and he might end up as your attorney. It sounds like you and Ms. Patel did not develop a trust-based relationship, and you need to have that with your attorney. And so my question for you is whether you are willing to give Ms. Feely an opportunity to demonstrate to you that she is zealously advocating for you, so we can see if that's how it's going to work out. If it doesn't, I'll get you another lawyer. That slows things down because Mr. Clattis, that's the name of our conflict defender, he would start brand new. He would need to get the case file from the public defender's office, see what's going on there and get to know you. And we can do that, but it slows things down. So tell me if you, Mr. Johnson, are willing to spend a little time with Ms. Feely, have her give you the discovery to which you are entitled. You're exactly right about that. And see if you and Ms. Feely can develop a meaningful lawyer-client relationship, so that then she in turn can help you figure out what the right next step is in your case. Is this a case you're working out? Is this a case that's going to trial? That's a decision that you and a lawyer you trust need to make together.
Yes, sir, I understand. I have no problem with trying to see if we can work forward to getting this rectified.
Okay.
Move forward.
Well, let me ask Ms. Feely a few questions. Ms. Feely, I know you are newer to the case, not new to lawyering or being a criminal defense attorney. Would you in the next, and you can define that window so we're managing Mr. Johnson's expectations in the next week, 2 weeks, would you be in a position to meet with him? And I'm happy if the bond doesn't make it clear he can come visit you, but it may be easier for Mr. Johnson if you visit him. You guys can sort that out. But does your schedule, given that you do have other cases in this division, permit you and an investigator to meet with Mr. Johnson so he can, one, get discovery, and two, you and he can start talking about the ins and outs of the case?
Yeah, sure. I will coordinate with my investigator to meet with him within the next couple of weeks.
Okay. So, Mr. Johnson, I just heard Ms. Feely on the record, because we're taking this down, commit to meeting with you and her investigator in the next couple of weeks. I'm going to leave it to the three of you to figure out, is that at Mr. Johnson's residence or is that at the public defender's office? And what I'll look for from Ms. Feely is an update as to how that went, and if it looks like a productive working relationship is developing. And Mr. Johnson, there's no need for you to remain silent for the next few months. If you conclude, and I'd hope you'd give Ms. Feely a couple meetings worth, that is not working out, you're always able to write the court to say, Judge, there's an issue here. And then we can get you back in court in person or virtually to have a discussion about alternate representation. I just want to caution you in the end, and I'm not saying this is you, but there are defendants out there. If you keep managing to have a relationship with a lawyer that goes south, I eventually figure out it's not the lawyer, it's the client, and you'll reach a dead end where I say, this is the lawyer you get. You can represent yourself, which is never a good idea, or you can work with this lawyer. But there is not an infinite supply of lawyers, and we're going to keep going until the shoe fits just right. But you are unquestionably entitled to a lawyer who has your best interests in mind, who is responsive to your questions and concerns, which doesn't mean if you're calling Ms. Feely every day, she's going to call you back every day. I'm not saying you've done that, but I just want to manage everyone's expectations. There's too much going on in everyone's life. Unless it's the eve of your trial. If you're going to trial next week, you and Ms. Feely may be talking every day, but your trial is a little ways down the road. And so she is juggling a number of clients. You are one of them, and she needs to take that relationship seriously, and I know she will. So are you willing to give this a chance, Mr. Johnson?
Yes, sir. I'm willing to give it a chance.
Excellent. Then expect a call. Well, do you have a way of contacting Mr. Johnson, Ms. Feely?
Yes, I have good contact information for him.
Great. Then expect a call or email, whatever method you all have developed, Mr. Johnson, in the next few days, lining up when in the next couple of weeks you and Ms. Feely can meet face-to-face papers can be exchanged, et cetera, so that you can see the discovery in this case. You did hear what Ms. Feely said, which is there's not a lot of discovery. So I don't want you to immediately have a negative reaction if the stack of papers Ms. Feely gives you isn't that thick. I'm looking at the charges here. It doesn't sound like it's a complicated case. It doesn't mean it's an unimportant case or that the feelings involved aren't complicated. But a case like this, absent excessive medical records, isn't going to be all that voluminous. And I do see that the medical records were provided. So you'll get the chance to look at those as well. And then hopefully you and Ms. Feely can start figuring out how we're going to try to resolve this one. Okay?
Yes, sir.
Did you get to share with me everything you wanted to share, or was there more, Mr. Johnson?
Yes, sir. It was an abundance of things that was going on. And Your Honor, the thing with me is this. I sat back and I tried to go through every process that I had by law to get proper, responses and get also someone to try to look at the situation that I was going through with this attorney. And I was given different, negative conversations by people at the public defender's office. I was denied access to speak with the actual, head of the public defender's office. I was told by Ms. Patel's supervisor that she would get back with me, and she was non-responsive. It's just that this is my life, sir. And like I said, I'm going through a lot physically and emotionally with this case. And I just want to make sure I get fair representation. And from what I've been seeing, these people are, well, I'm not going to say the public defender's office, but Ms. Patel and her supervisor were totally unethical. They lied to the court. They lied to me. They tried to withhold information and blatantly, tried to actually influence people not to be allowing me to bond out of jail, which caused me to spend more time in jail. It's like the situation is so frustrating. You would not understand sitting in court with someone or having your case or your life handled by someone you have already seen that has the capability of manipulating you and also putting you in a situation where you may lose years of your life, right? And that's a great concern to me.
Right. And I'm hearing you on that. And I appreciate you paused for a moment and you weren't going to generalize. I'm sure you wouldn't want me to generalize like, oh, here's a guy charged with aggravated assault. I know what Mr. Johnson must be like. And I won't, and I'll let you help me understand who you are when the time is right. If there's a plea or there's a trial, if you're found guilty, I need to figure out who Anthony Johnson is before I figure out what I'm going to do with it. You need to figure out who Ms. Feely is. Ms. Feely is not Ms. Patel. Ms. Patel is no longer on the case, and you're going to go in with eyes wide open. That is very clear, and it is also clear to me as Ms. Feely will. We'll see what happens. And like I said, if for some reason that's not a relationship that begins to gel, then we need to have another conversation. And I'm not going to be interested in saying, let's try another public defender. We'll just shift offices and we'll get you to the conflict defender. That will be a time setback for you, but you are unquestionably entitled to a lawyer who's got your best interests in mind. You've said that well, and you certainly know your rights. And one of my roles is to make sure that your rights are protected and vindicated. So I will be a participant in this process. We will see you much sooner than I last saw you, because I'm going to give Ms. Feely the time she's asked for to connect with you. And then we'll figure out what's happening next with your case. Okay?
Yes, sir.
All right. Mr. Thomas, anything else in Mr. Johnson's case?
No, Your Honor.
You'll get that offer to Ms. Feely soon. So that's part of the conversation she could have with Mr. Johnson when they connect.
Yes, sir.
Fantastic. All right, Mr. Johnson, thank you, sir. You are free to leave if you'd like to.
Thank you, sir. Thank you.
You're welcome. Have a good weekend.
You also.
All right, the next position is Quintavious Curry. Is Mr. Curry here?
Judge, he's in custody in Phillips State Prison.
Phillips State Prison, okay. Hold on one sec. Go. So we need to, do you want us to get him, not today, but just bump this status conference to another date so he's in the mix?
I would appreciate that, Judge. I have a call scheduled with him next week, so that would be, and Ms. Charles and I have spoken about discovery. This was originally assigned to Judge Leffridge's courtroom. She had to, yes.
And let me guess, her staff attorney So it's our case now. Okay. These things happen. And when you spoke with Ms. Charles about, we'll have our mini status conference right now. Are there discovery issues?
Well, so the issue was it was assigned to a different prosecutor, different public defender. So that's part of the shuffle. I do have discovery. We haven't been able to go through it all.
Okay, so you, Ms. Wood, have whatever Judge Leffridge's ADA produced, but Ms. Charles is needing to learn sort of like you. Is that necessarily everything? Okay, all right. Do we know how long Mr. Curry is expected to be with the Department of Corrections?
Yes, Judge, 3.5 years.
Okay. All right. Then why don't we reset this to a date when we can make that connection with Phillip State so he can be in the mix? That will give both of you a chance to figure out what has been provided in discovery, what's not, so that when we get Mr. Curry on the call, you'll be able to have a better sense of, yep, I've got everything. Just looking at the charges, it sounds like there'd be some body cam or car cam going on, dash cam, I guess they call it. This says Mr. Thomas's name on it, but I'm looking at Ms. Charles. Unless Mr. Curry had a good relationship with the officer, I don't know why it would be Mr. Thomas.
Exactly. I was ADA and Leffridge.
Oh, so this is why the discovery is no good. Now I understand. All right. Now that I know the source. Ms. Feely, well, we're not on the record in this one because we don't have Mr. Curry. In Mr. Johnson's case, if you could file an entry of appearance, that will remove one name from the case and add another, and I think would be productive. So we'll get Mr. Curry on from Phillip State, and it'll be Ms. Charles's case. Ms. Wood is on it, and we will talk about next steps, or because we'll have them online and it's workoutable, we'll take a plea. We'll see. Co-Defendant. All right. Position 4 is Ms. Williams, who is on Zoom. I saw her when I logged on. Ms. Williams, you there? There she is.
Yes, I'm here.
Great. All right. This is position 4, 22 SC 180634, State versus Breonna Williams. Ms. Charles, is it your case? Okay. So it says Ms. Charles, but it's Ms. Thomas, Mr. Thomas, the reverse of the last one. All right. Mr. Thomas's case, and Ms. Wood, you represent Ms. Williams.
Yes, Judge.
All right. My look at the docket says we are in the right space having a status conference. The discovery picture for the defense is?
I believe we are just missing body camera if it exists. I need to get with ADA Thomas. I had talked briefly about this case with ADA Besa. So we were working towards a resolution, and that's still in play. Ms. Williams has a newborn, so giving her a little bit of time, but I do expect this to be a non-trial resolution.
Okay. Do you know, Mr. Thomas, if there is body cam video?
I do not know, but if there is body cam, is APD, it shouldn't be hard to get. So I will make sure she has a body cam, and I think we'll be able to come to a resolution here pretty soon.
Ms. Wood, any reason to believe that the body cam video would have custodial statements of Ms. Williams that might require us to litigate before you'd be comfortable resolving the case, or you think it's resolvable regardless of what's on the body cam, unless it's absolutely exonerating your client?
I think it's resolvable, Judge.
Okay. Then if I move Ms. Williams's case to a trial calendar that is a couple months out, is that enough time for the two sides to do what they need to do?
Yes, Judge.
Okay. Ms. Williams, how old is your newborn?
She's 3 weeks, and that's the problem right now because I'm trying to get it resolved because Dad is on the case as well. So we're trying to get to a resolution to where the baby, I guess, and him can be involved with each other. So, she's brand new.
So 3 weeks is very young. Congratulations. Is that
Thank
your
you.
first?
This is not the first. This is the second.
Okay. Still congratulations.
Thank you.
So Mr. Scott is the father of the child?
Yes.
Okay. So that makes it complicated. My guess is you're supposed to stay away from Mr. Scott right now.
Yes.
Okay. All right. Well, this is not the first time we've had cases with these dynamics. So we can work on that. It sounds like Ms. Williams, that Ms. Wood will be connecting with you soon to talk a little bit more about working the case out. Are there other care providers for your child, or are you it right now?
I'm solely it. Me and his sister have been in contact. So as of now, we're just waiting on the court case to be resolved.
Okay.
To move forward.
When you say his sister, you mean Mr. Scott's sister?
Yes.
Okay. And is Kinsley Williams your other child?
Yes.
How old is Kinsley?
Kinsley's 8.
8. Okay. Got it. Mr. Thomas, anything else in Ms. Williams's case?
No, Your Honor.
Have you, I guess it was Ms. Beza who may have communicated an offer or initial conversations. Any reason why you wouldn't be able to plug in fairly seamlessly to those conversations?
I don't see any issue, Your Honor.
Okay. All right. Ms. Williams, do you have any questions for me about what's going on with your case?
No, sir.
Okay. Will you continue to take, what is your new child's name?
Her name is Chloe.
Chloe. Will you take, is Chloe doing well?
Chloe is doing great. Chloe
Excellent.
Scott.
Chloe Scott. All right. Well, you take care of Chloe. Ms. Wood will be in touch with you, and it's sounding like your case is going to resolve short of trial. And if that's how it's going to play out, when we can make that happen, we'll get you either physically in court or connected in this way again.
Okay.
All right. If that is it for Ms. Williams, she is free to drop off the call.
Hi, Ms.
All
Williams.
right. Thank you.
Bye-bye. All right. Next, position 5, State versus Rodriguez Coleman.
That was my case. I was not able to reach Mr. Coleman. However, I reached his mother, Linda Cooper, who told me that he should be getting out of rehab pretty soon. Now, I do not have documentation of that, but
Okay.
he is also a resident of Tennessee.
Mr. Coleman is.
Yes, and so with the court's indulgence, I understand that a bench warrant may be warranted here, but if I could maybe provide that documentation when I get it, or if I can reach Mr. Coleman himself, maybe we could have him appear virtually to avoid having extradition from Tennessee.
Right. Be great to avoid that. Let me see what's going on in his docket. You all right? Yeah, so he did change his address to Memphis and appeared virtually when that was happening. So let's see. That's what's in the system. How much, not very much time do you want to see what you can learn about him before I ask the state to prepare a bench warrant?
I could have maybe maybe till Tuesday,
Hmm.
and that way I'll know one way or the other.
Okay. This again says Ms. Charles, but I'm thinking it's Mr. Thomas.
Yes, Your Honor.
Big day for you.
Yes, it is. Your Honor.
A lot of these ag assault cases. Okay. So my proposal, Mr. Thomas, is that I'll make a note to see what we hear from Ms. Feely by Wednesday of next week. If we've heard nothing or we've heard something unpersuasive, then I'm going to do a bench warrant for Mr. Coleman. But maybe we get Mr. Coleman virtually, whatever. Then we can have the status conference. We'll have an informal one now. Are there discovery issues in the case, Ms. Feely?
So I don't have any media, but it could be that I just don't have access to what was shared before. So I can get with Mr. Thomas and see if he can get me 911 call, body cam, or whatever exists. I just have paper discovery at this point.
Okay. Do you know, Mr. Thomas, if there is digital discovery in this case?
Not for sure, Your Honor. I can check and make sure if there's there, she'll get it.
Okay, so for future reference, I don't know, maybe your laptop has a lot on it. You should come to the status conferences aware of what the universe of discovery is, so that if Ms. Feely is saying, I don't have any digital discovery, you're in a position to say, because there isn't any, or probably Ms. Patel got the evidence.com link, and maybe she downloaded it, maybe she didn't, but I'll just resend you the evidence.com. The status conference is a time for us to make sure discovery is complete. And that means I need the state to be ready to say, this is what we think complete discovery is. There was a 911 call, there was a helicopter chase, whatever it is, that then the defense attorney can say, oh, I've got all that, so we are good. So for your next status conference calendar, number one, please try to push an offer across beforehand. And number two, please, however you want to have it with you, computer, notes, have a pretty good sense of what's in discovery. And I don't mean what's on page 14 of the officer's report, not that level of granularity, but there are medical records, there aren't. There is body cam, there's not body cam. So that then I can, because what I do flowing from this is I make a list. I know that, well, there weren't any so far today. Well, there is in Ms. Williams's case. I'm going to make a note that there's body cam video that Ms. Wood doesn't have. I don't think that's a reason to delay the Williams case from a trial calendar that's a couple months out, but sometimes it might be a big one. The defendant statement, I don't have that yet. Well, I don't want to put this on a trial calendar yet because we may have to litigate the admissibility of the statement. So for future reference, if you could have that, that would be great. All right, so Ms. Feely, my notes for Coleman will be that you've got till close of business Tuesday to let Mr. Thomas, Ms. Nelson, and me know via email what you've learned about Mr. Coleman's whereabouts. Okay. Position 6 is State versus Vadluri, and I think we've got Mr. Vadluri on the call, and we have his lawyer on the call as well. Let's get them spotlighted. Mr. Schiffer, there he is, spotlighted, and Mr. Vadluri. Oh, you went away. There he is, Mr. Vadluri.
Oops, sorry, Judge.
All right, there you go. Can you hear us, Mr. Vadluri?
Yes, sir.
Good, excellent. I'm going to ask you to mute again, and then if we've got questions from you, Mr. Vadluri, in fact, I'll mute you. It sounds like someone is playing a very loud game of billiards in the background there. So I'll have you come off mute if I need to hear from you, Mr. Vadluri, or if you've got any questions or concerns. This is listed as a Siri Patel case, but it's a Mr. Thomas case?
Yeah, Your Honor.
All right. Okay.
Judge, I think we can make this very, very quick, Your Honor. Mr. Vadluri's case, everything's great, except that the state, this was originally a misdemeanor, and we had one outstanding piece of evidence, that being some body cam videotape. And there was a lot of back and forth about trying to get this video, and the state tried to send it a number of times. I went and met with Mr. Thomas yesterday about getting this, because it's been a struggle. And it turns out that the video has been lost in between the solicitor's office and the DA's office. So Mr. Thomas informed me he's going to go back and get the video directly from the arresting agency.
Which is what agency?
Sandy Springs.
Sandy Springs, Your Honor.
All right, so body cam video from Sandy Springs. And Mr. Schiffer, you believe this body cam video is of what?
Oh, it's extraordinarily probative value. It is the body cam of the report and the scene. This is a basic DV that started out as a misdemeanor, and then during the time of review, it was requested to be moved to Superior Court. Mr. Vedlury has complied with all bond conditions. He's had no contact with his still current wife and parent of his child per the bond conditions. He continues to support them. And we think this is going to resolve. We just need to get this video so that Mr. Thomas can review it and he and I can sit down and meet and get this one negotiated.
Okay, so you believe the body cam video will be productive in terms of resolving the case, not that you need it so you can file a motion?
Yeah, no, I don't believe there's a motion that's going to come out of it unless it contains some stuff that I don't really expect it to contain. I think it's going to be pretty straightforward. I just know that I need to see it and DA Thomas needs to see it so that we can have a full picture of the incident. This was a kind of complicated incident due to the lack of English as a first language, as well as obviously the emotions involved in any domestic dynamic.
Got it. Mr. Thomas, how much time do you need to obtain this video?
So, Your Honor, Sandy Springs is pretty responsive, so I should have the video within a couple of days. I should be able to serve to Mr. Schiffer within 7 days. So we reach out at least 7 days out.
Okay.
Maybe at least 2 weeks out to give it those time to review.
Sure. So if I put this, hold on one sec, there's a loud phone in there, just muted it. If I put this case on a trial calendar that is kind of midsummer, August or September, that is plenty of time for the 2 days to get it from Sandy Springs, the week or two for Schiffer and Thomas to review and discuss. And then there's no need for you all to wait. If the result of reviewing the video is a negotiated resolution, please let Ms. Nelson know the case has been resolved, meaning ready for a plea, and we'll get you in here well before the trial calendar. The trial calendar is when we would try the case, not when we would plead the case. So if Mr. Schiffer, you believe that it's reached a negotiated resolution or non-negotiated, but close enough that your client wants to go forward, then please let Ms. Nelson know. No need, if the resolution would allow Mr. Vedlury to reunite with his wife or at least spend time with his kids. I am not requiring anyone. In fact, I am discouraging people from waiting till the trial calendar date. That's when we'll try the case. And it doesn't sound like that's what this needs to be. But it also sounds like a August-ish, September-ish trial date gives everyone more than enough time to do what needs to be done. Fair statement, Mr. Thomas?
I agree, Your Honor.
Mr. Schiffer, that work for you?
Absolutely, Your Honor. Thank you so much.
The one other request I've got of you, Mr. Schiffer, is that if you review the video and the contents don't result in a let's work this case out, but they do trigger a concern about its admissibility, then please don't just file your motion, but let Ms. Nelson know that you've got it, because I'm not changing the trial date and I want to fit that motions hearing in beforehand so everyone knows what's coming in, what's not coming in at the trial.
Yes, Judge, absolutely. I expect this as soon as we get the video and I get an afternoon with Mr. Thomas. One of us will agree with the other one of us and we'll get it figured out.
Okay. Is viewing the video going to require an interpreter?
Oh, no, Judge.
Okay.
It's scene setting and illustrative of the issue. I believe, Mr. Thomas, your victim witness, does it have contact with the complainant, and has it maintained contact with the complainant?
Yes, sir. We do have contact with the victim.
That was my only real concern, but we should be able to come to a meeting on this one, Judge.
All right. Sounds good. Mr. Vedlury, do you have any questions of me, or are you good to go? So you're on mute, but if you're good, you can just put your, yep.
I'm good, sir.
Good to go. All right. So, Mr. Vedluri, just remind you, you need to continue to comply with the conditions of your bond. And if that requires the unfortunate situation where you have to stay away from your wife and or your child, you'll need to continue to do that until your case is resolved. Okay?
Yes, sir.
All right. You are free to go. Thank you, Mr. Schiffer.
Thank you, Judge. Pleasure to see you as always. And before I leave, I'd like to introduce to the court, sitting behind me to my left is Miss Marion Crossfield. She graduates from North Georgia University, the former North Georgia College, strong military tradition. And she has specifically been interested in practicing law and criminal law. So she is my summer intern this year. And this is her second day and her second court. And there's not a better one for her to come and observe than Fulton County. So thank you.
Welcome aboard. You're going to have an amazing summer, and you're going to see a lot of things that will open your eyes wide, and you may leave the summer saying, you know what, I don't want to do criminal law. But it's a fascinating field, and I wish you the best. If there's anything I can do, just let Mr. Schiffer know. He can figure out when we're in trial. If I'm not, a colleague will be. He will be, so you can just follow him around. But there's lots going on down in Fulton County, okay?
Thank you so much, Judge. And I will probably reach out. She's already going to be visiting with Judge Childs in Fulton or in Cobb County, who's a UNG graduate. And then this afternoon, she's going to go to Canton, where Mr. Mitch Skandalakis and I are going to be arguing an immunity motion in front of Judge Cannon that involves a football player, DV, and a dismissed civil case where the victims have retained their own civil rights attorneys. This is Zenobia Waters. So it's going to be fun at 2:30 today. She's never going to see another hearing like that. Mr.
No.
This is quite a fun co-counsel for me.
You are starting strong, Well, good. Well, enjoy the summer.
Thank you so much, Judge.
All right. Take care.
Take care. Bye.
All right. Position 7 is State versus Cornell. Galbraith.
Good morning, Your Honor.
Good morning, Mr. Butterfield. Good to see you.
Always a pleasure.
The 3-piece seersucker. My goodness.
I knew I was coming to see you.
Yeah.
Always a pleasure, Your Honor. We have received discovery in this matter. Our prosecutor has been kind enough to give us that back in March. This is a very straightforward case, Judge.
How many times have I heard that? Yeah, especially from you.
If we had to go, there are no issues as far as we're concerned, as far as witnesses out of town or any complex issues. If this case were to go to trial, and I expect we're going to resolve it, it's only like a 2-day trial. To speak to the jury and argue the case. And
let people say what happened and let the jury decide.
Yes. So it is our hope and prayer that we can resolve this with a pretrial diversion. However, prosecutor informed me today there are some medicals that she was informed of that may determine which offer she's going to make us. So we don't have it was a possible pretrial offer until she learned about the medicals, is what I understand. Is that correct?
Yes, that's correct.
So let me ask a few questions. That's a helpful update. And hello, Mr. Galbraith.
How you doing? Are you doing?
I'm doing all right. This is your case, Ms. Charles. Okay. I can never tell from the charges, but all right, it's your case. How did you just now learn? I don't mean this moment, but this case has been around for a little bit. How did medical records just come to your attention?
Oh, we've been requesting the medical records. We don't yet have the medical records. The victim was supposed to try and get it to us directly. It didn't. It's
always easier that way.
Yes, it was. So my investigators requested it. We're just waiting for that to come in to determine. He described his injuries to me, but I would like the records to come in so I can corroborate the extent of his injuries, and that will determine where we end up finally.
What is the medical provider?
Piedmont Hospital.
Okay. And do you and your investigator have a good track record in getting things from Piedmont?
Well, we were told it's going to be about 2 weeks. So hopefully by the end of next week, we should have that.
So your request was made about a week ago?
Sure.
Okay. It sounds like absent there being a bottleneck there, we could put this case on a trial calendar that is in that time frame we've been discussing today, August, September. And well before then, you'd have the medical records, and still well before then, you'd be able to sort the case out, unless the medical records really just upend Mr. Butterfield's perspective of what the case may have been for his client.
Yes.
Okay. That makes sense. Mr. Butterfield, anything else on behalf of Mr. Galbraith?
Nothing further, Your Honor.
Piedmont. Okay. And Mr. Galbraith, you've been complying with the conditions of your bond?
Absolutely, yeah.
They're not too onerous for you?
That's right.
Okay. Ms. Charles, anything else on behalf of the state?
No, Your Honor, just those records we're just waiting for.
We're done. Have a good weekend, everyone.
Thank you, Your Honor. May we be excused? That
Yeah.
concludes my business today.
Yes, sir.
We'll talk. All right, thank you very much.
You're welcome.
Have a good day.
All right. Position 8 is State versus Wilkes. Is Mr. Wilkes here? Come on up, Mr. Wilkes.
Good morning.
Good morning. How are you?
I'm doing great. How are you?
Okay. Just pulling up your case. All right, let's go on the record. 22 SC 180793, State versus Wilkes. Mr. Wilkes is charged with aggravated assault with a deadly weapon. Ms. Wood, any discovery issues?
No, Judge, I believe we have everything on this one,
Excellent.
except an offer.
Accept an offer. All right. Well, we're getting used to this status conference flow and what all we're doing here. And I may not have mapped it out as clearly. I know I did in my mind. But Ms. Charles, any reason why soon?
Thomas's case.
Mr. Thomas. All right. I'm just going by what it says on the calendar. All right, Mr. Thomas. Well, now I know why you don't have an offer, but next time you will. Any discovery issues you can think of or anything that would prevent Mr. Wilkes's case from getting to a trial calendar?
No.
All right. And you will, in the next week or so, communicate an offer to Ms. Wood.
Yes, Your Honor.
All right. Mr. Wilkes, do you have any questions about what's going on with your case?
I know he's very eager, Judge, to resolve this case. This is his first arrest, and so I'm hopeful that we can take care of this fairly soon.
Okay, so Mr. Wilkes, as soon as Ms. Wood gets an offer from Mr. Thomas, she can start talking to you about, well, the state may be here, meaning higher than you want, and you want the case to be resolved this way. See if there's a way to bring it together. It may be what Mr. Thomas has to offer you think is fair and reasonable. If there ultimately is a meeting of the minds, you and Ms. Wood think that the state's offer is fair and you want to go forward with a plea, or even if there's an almost meeting of the minds, what you think is fair and what Mr. Thomas thinks is fair is close, it may be that you and Ms. Wood say, let's get in front of the judge and take a plea. And we can do that. Otherwise, I'm going to set your case down for trial. Because I'm anxious for your case to be over with as well. And it's going to end either because Mr. Thomas says we dismiss, that doesn't happen all that often. You say I'm going to plead, or a jury hears it and then they say guilty or not guilty. Those are the typical three outcomes. And I need to make sure we get you to that direction so that this isn't hanging over your head too long. It's not a particularly old case. It may seem like it's been around forever for you. In the grand scheme of what we do in Fulton, it's not so old, but that's not a reason to slow it down. Your lawyer has all the discovery. So if it can't be negotiated, let's get it in front of a jury. Okay?
I'm going to step out, Judge, when we're done here and go over some of these other questions.
Sure. Great. Well, Mr. Wilkes, you are free to go. Mr. Thomas will get that offer to Ms. Wood, and we'll see you either because you're working the case out or because we're going to have a trial.
Thank you, Judge.
Mr. Thomas, anything else in the case?
No, Your Honor, have you excused?
if that's your last case. The other two say Ms. Charles, which often means Mr. Thomas.
No, they actually are.
All right. You're free to go. Have a good weekend. All right. Last case is co-defendants. We've got Mr. Cano. Is he here? He is. And Mr. Johnson.
On behalf of Mr. Johnson, Ms. Rockwell will probably be doing the entry appearance on the case as well.
Where's Mr. Johnson? Oh, he's online?
And of course, he's present.
There's Mr.
Update his address, Your
Hold
Honor.
I just want to know who's here. All right. So is that Mr. Johnson on the screen? All right. So there's Mr. Johnson. You're Mr. Halliburton. And then Mr. Ford is on. Let me get him on the screen.
Good morning, y'all.
Morning. Let me add you. There's Mr. Ford. So Mr. Ford represents, is it Cano or Cano? I don't want to mispronounce it. Cano. So Mr. Cano is here. His lawyer's on the screen. Mr. Halliburton is here. His client is on the screen. And my thought is we just jointly do the status conference because it's the same discovery, et cetera. So let me get on the record and then I'll hear from each of the lawyers. All right, this is 22 SC 180-840. And we've got our two defendants, our two defense attorneys, and Ms. Charles is the prosecutor. Mr. Ford, do you have all the discovery you think is out there?
I'm certain it has been provided. I can't tell you I put eyes on it from Ms. Charles yet. I know there are medical records that may be outstanding that could be determinative of the state's offer. So it's an ambivalent response, respectfully.
The last part I didn't hear.
That's I gave you an ambivalent response. I'm sure they'd give me what they have. I don't think I've seen medical records.
Medical records. That was the part. Okay. No, I heard the ambivalent part. I just wasn't sure what you thought you were missing. Ms. Charles, are there medical records in the case?
There are, Your Honor.
And have they been part of what you provided?
When we sent initial discovery, it was my understanding that they were part of the initial discovery. If they weren't, I'll go ahead and have that redisclosed. My understanding of what was outstanding were the videos from the bar, which we later recovered, and that was emailed as an evidence.com link to both attorneys in for both cases. However, I'll make sure Mr. Ford gets the medical records again.
Okay.
I would ask if you guys give me that link for evidence.com again. I've had some technical challenges, but I will make certain that I pay attention and open up in a timely frame and get it to Mr. Cano.
Okay.
All right. So if you don't mind, Ms. Charles, repeating the work you've done before, send the medical records to Mr. Ford and the evidence.com link. And it may be that the evidence.com link accomplishes both things if the medical records are part of the evidence.com link.
They were in Odyssey. What I'll do, I'll upload them to evidence.com and just do one.
So you'll send Mr. Ford one link and in it will be bar surveillance camera and medical records. Great. Mr. Ford, if we do not hear back from you, email to Ms. Nelson and Ms. Charles within 2 weeks that you're having technical difficulties, silence will mean that Ms. Charles did what she needed to do. Okay?
Understood, Your Honor. And I would anticipate that all things being equal, this is probably a case we can resolve short of trial. An offer has not been conveyed yet, but that's what I think the status of the case is.
Okay.
It's possible.
I'll be hopeful.
All right. Now let's turn to Mr. Johnson and Mr. Halliburton. Mr. Halliburton, you jumped right in and said, wait a minute, Renee Rockwell. Is Renee Rockwell joining you or supplanting you?
She might be doing an entry on the case. Right now, it's just me. I did an entry on the case. I do know Mr. Ford. I'll be reaching out to him. I concur with him on this case. I think we'll be able to get it resolved short of trial. Mr. Johnson, of course, is present. Your Honor, I was able to finally reach him this morning, so he's not dressed appropriately. He did not get notice. Just want to notify the court. He is a disabled vet. He definitely likes to present himself well if he ever has to come to court. And so I apologize for the decorum in that matter.
I am okay with that. Decorum, if we have got a trial, he's going to want to have a tie on. Otherwise, What's important is that we've got Mr. Johnson. So don't sweat the t-shirt. No disrespect taken. I'm just looking at the docket. So I'm clear. Ms. Rockwell, if she files an entry, she would be co-counsel with you. Okay, so it's not that we would need to, we have to stop everything. Halliburton is out and Rockwell is in.
Your Honor, I'm in on the case, Mr. Johnson is a long-time college friend of mine.
Okay. Now, do we need to update Mr. Johnson's address?
I will do
Because
that.
you said he didn't get notice, and just so we know, so he knows, Mr. Johnson, the address of record where your correspondence is being sent is an apartment on Roswell Road. Do you still live there? I muted you just because there was some background noise. If you don't mind. Okay, that's still apartment 6J, 6 Johnson. That's still okay. Then you should be getting notice because that's where it's going. Your lawyers will keep you posted as well. Mr. Halliburton, what's your announcement about discovery? Do you feel like you've got everything?
Your Honor, they've been very forthcoming. I was actually very impressed. I did an injury appearance and I got a link immediately, and I haven't been able to download that link yet, some type of zip drive, but I'm learning the system on that.
Okay.
And then my office, I have an office in Atlanta and Carrollton, Georgia, and I got something from from here last week, so I presume that's the discovery. I haven't been able to look at it, so I kind of second Mr. Ford's position, and as long as there's no medical surprises or anything like that, I think they'll resolve the case. But the state has been very forthcoming and very much appreciated.
So what I'll ask Ms. Charles to do is just to send you the same link she's sending Mr. Ford. You'll be getting things you already received, but maybe you'll have fewer technical difficulties this time. It's on you to find the resources to open it because what's being disclosed is accessible. It's how evidence discovery flows back and forth between the DA's office and the public defender's office all the time. So I know it works. It just may not be what you're used to. And so there may be some things you need to click that you don't normally. Please reach out to Ms. Charles. She's going to be super supportive and she'll say, click here, use this. There's no shame in doing, hey, I can't open this file. What I don't want to have happen is we get together again. You're like, yeah, she sent me this thing and I couldn't open it. The time for doing that is the next couple of weeks because this will appear on a trial calendar next. That doesn't mean it has to be a trial. And if you reach the point that you think you've resolved the case for your client and Mr. Ford has done so for his client, then we should get folks in here and take the plea. It creates congestion and it's stressful to take the plea right off the trial calendar. The trial calendar is going to be far enough out. You ought to know pretty far before then if it's a case that can work out. And if it can't, we can have a trial. That's fine. We'll just see how things flow. Mr. Halliburton, did you have anything else you wanted to share with me about your need to prepare?
Do not, Your Honor. So it's my understanding that you do have a special plea calendar. If we do agree to that, it would be put on the plea calendar.
Exactly. You and Ms. Charles and Mr. Ford would reach out to Ms. Nelson saying, we've sorted this out. And then she would say, great, we'll see you. You can decide whether it's virtual or in person. I'm fine either way. If someone's going into custody, virtual don't work so well. But if it is a non-custodial resolution, as long as your client will waive on the record his right to be in court, or if you're here in person and he's not, his right to have you by his side, we can take the plea that way. So that'll be the question Ms. Nelson asks is, are you coming in? Because if you're all coming in, we can do it almost anytime. If it's going to be Zoom, we just need to schedule a little bit differently. But it's easy to do. You just got to make the outreach.
I'll coordinate with Mr. Ford and Ms. Charles. I know them both, so we'll try to resolve.
Good. All right. Not quite yet. Mr. Ford, anything else you want to add now that you've heard from the Johnson Halliburton side of things?
Well, yes, if Ms. Charles is available for a brief conversation this morning, it might be efficient for she and I to talk.
Okay. Well, we are done once I excuse you all because these are the last two positions on the calendar. So I don't dictate Ms. Charles's schedule. She may have to run off to an important thing.
You want to have a bond set for today as well? A bond hearing at 10. Oh, am I?
Oh, that's not on the Outlook calendar. I'll do it. It's just not on that. The only thing on the Outlook calendar was our invite is the status calendar.
Well, I could reach out to Mr. Ford after the bond hearing. I
Yes,
get
so
back to
Mr.
you.
Ford, you know how to reach Mr. Ford? Do you need a number for him?
I have his information.
So Ms. Charles will reach out to you, Mr. Ford. We apparently have a bond hearing. And we'll work through that. And then Ms. Charles will be free.
Yes.
All right,
Available on my cell at your convenience. Thank you all. Good night.
Thank you.
fantastic. All right. Mr. Johnson, you are free to go. Appreciate you dialing in, okay? Have a good weekend.
You too.
Let me just see.
Mr. Cano, you're good to go. That's okay. If they want to attach that, I can roll with it. So I think you guys are done, public defenders. You're not done? Is there another calendar?
Well, there's the Virgin Islands matter.
Oh, right.
Yes.
Okay. Is that Mo?
I'm trying to figure out.
Yes, sir. Thank you. Appreciate you being here. So we've got a defendant, Mr. Santiago Cano. Does he need an interpreter? Let's ask Ms. Hingerty. Ms. Hingerty.
I think it's not. Your Honor. I think he's in custody as well, Your Honor.
We should be. It's a bond hearing.
I know. No.
Ms. Hingerty, does your client need an interpreter?
He does not need an interpreter, Your Honor. I believe we've been able to communicate with him just fine.
Okay. Well, when he comes out, I'll ask anyway. Are you all here for? Yeah. Does he need an interpreter? Family is saying no, he does not. So
I don't think so, Judge.
We'll bring him out. We also have a call with the Virgin Islands we're trying to have happen. So
That I want to be an in-person.
yeah, I know. I said I need to preside over that where the defendant is.
I know, let me go get on a plane. I will be right there for the hearing.
Yeah.
Get on for free.
Yeah. Pro bono representation.
Right.
Well, let's do the bond hearing, and in the background, folks can try to figure out where the Virgin Islands link is.
Well, you just cut us off if you need to, Your Honor. We're
Okay.
here. So before you, I guess he's not out yet.
He is not out yet.
So I guess I'll wait. Your Honor, we have a new me here in JF's office, and he is sitting in on this bond hearing. Let me see if I can show you, introduce you to Doug. Well, you know what? Let me unplug here. Introduce you. Oh, no.
Oh, no.
That's just on this. They can still see us. Can you still see us, Your Honor?
I can see you.
Can you see Doug? There he
Hello,
is.
Doug.
Hello, Your Honor. Very nice to meet you.
Nice to meet you. When did you join the app team?
On this past Monday, Your Honor.
Well, that's recent. Where'd you come from?
I had my own practice, and prior to that was with a couple of big firms.
Okay.
He escaped Jones Day, Your Honor.
Oh, all right. Well, congratulations on your liberty.
Thank you.
Yep. There was a certain lightness about you that said you had escaped something heavy.
Yeah, you could detect that, huh?
That's funny. All right.
The current state of my office. We've been in trial and it looks like a bomb went off in here.
Let me get Mr. Santiago's case up and then we can get going.
Javier, you can understand us okay? You don't need an interpreter, is that correct?
No, ma'am.
Well, she asked you two different questions, but you don't need an interpreter, correct? Okay. So we've got a co-defendant, but that's not who we've got here.
Ms. Castillo.
Yep. Just getting your indictment up here.
Mr. Santiago Cano is charged with counts 1, 2, 3, 5, 6, 7, 8, and 9. So not with count 4.
Right, got it. Did not allegedly assault Victor Castillo, who is apparently a relative of Jessica's. Okay. Ms. Rivers, you still with us?
Yes, Judge, I'm still here.
Great. Let's go on the record in 22 SC 180351. It's State versus Javier Santiago Cano. Cano. There was a defendant just here who just was Cano, and I said it wrong. And he said it's Cano, and I probably should have said the same way with you. Santiago Cano. Mr. Santiago Cano is here in court in person. One of his lawyers is appearing virtually. Ms. Hingerty is on the screen. You should be able to see her, and she can see you. I've spotlighted you, Mr. Santiago Cano, so that you are particularly visible for Ms. Hingerty. You can see her. Our prosecutor, Ms. Charles, is in the courtroom. I need to know, Mr. Santiago Cano, that you are comfortable proceeding with your lawyer appearing remotely rather than here in court. If you want your lawyer to be by your side, we can make that happen. We just need to do this hearing on a different day.
Oh, that's fine. We're like that, sir.
It's fine. Okay.
Yes, sir. That's fine like that.
All right. You're waiving your right to have your lawyer here. If you need to speak privately with Ms. Hingerty at some point, we can try to make it happen. It's a little complicated with this setup. It's a lot easier when the lawyer's here and the defendant is remote. But we could figure out how to make it happen if we need to. Usually in a bond hearing, that's not so necessary, but we'll figure it out. All right. So all we're working through today is bond. Your lawyers filed a motion for bond in your case. I'm going to get it up on my screen here. There it is. You were denied bond in December of last year, and they make the normal statements. You're not a flight risk, et cetera, et cetera. I will hear first from your lawyer, and then I'm going to ask someone from pretrial services who's on the call a little bit about your situation, and then I'll hear from Ms. Charles, the prosecutor, and I'll let you know what I'm going to do about bond. Okay?
Yes, sir.
If you have any questions while we're working through this, let me know.
Yes, sir.
All right. When you're ready, Ms. Hingerty.
Your Honor, good morning again. Before you, you have Mr. Santiago Cano, who was born on October 20th, 1995. By my math, that makes him 27. He resides, currently at Rice Street, but prior to that at 948 Cone Road, Forest Park, Georgia. So he is a resident here in town. He did attend Forest Park High School at some point in time. He's also educated in Bobcat. He's got several certifications, Your Honor, that makes him a good candidate for employment, with a Bobcat, with a crane certification, the crane magnet certification, and a heavy equipment certification. He's been employed solidly from 2014 on. He worked at Old Dixie Pine Straw in Ellenwood, at JFC International in Tucker, at Commercial Roofing, working with his uncle and installing from 18 to 19, and then at Amerigo Recycling Center in Lake City, Georgia, all here in the Atlanta area. He was born and raised in Atlanta at Grady Hospital and has resided in Forest Park his entire life, Your Honor. He has significant ties to Georgia with, I can see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. If Your Honor wants to hear them, but 13 immediate family members living here in the Atlanta area. It's my understanding that some of them are there in support today. So you can see he has a significant amount of community and family support, as well as ties to the Atlanta area. Prior to his being arrested, defendant did have 2 of his fingers partially severed during a work-related incident at the recycling center. And so he has a current workers' comp case pending. He has 2 stepchildren, Shaylin Castillo and Jaden Mejia, 10 and 5 years old, and 4 children of his own, Tatiana, age 8, Javier, age 6, Sergio, age 5, and Adriana, who is a baby. So obviously he needs to get out to continue working with his employment and to work on his workers' compensation case and receive treatment for his hand. all of which need to be done. I imagine with 6 children who are depending on him and on his employment, Your Honor, that's very important. He was sole provider for his family prior to his arrest. Your Honor, I do see that discovery was provided, or at least partial discovery was provided back earlier this year. But it does look like there were some allegations that the alleged victim in the case had been taken to Brady. I do not see any hospital records. I do see where he was returned home. He returned home of his own volition later that night. So where I see that there may have been an alleged injury, it doesn't look like it was anything more serious than taking him to the hospital to check it out. These allegations came from a 2020 incident report date. And obviously we're where we are now in 2022. And again, I do not see any medical records from Brady or from the state. I would argue, Judge, that it has been a significant amount of time, that we are still missing discovery, that he has 6 children depending on him, that he needs to work on his medical health and his medical representation on his workers' compensation case. He needs to work to provide for his family, and he needs to get out to help us in getting ready to present this case to Your Honor. He looks forward to clearing his name in this case. And that's all I have at this time, Your Honor. We would just ask that he be given a reasonable bond to allow him to get out and do all of those aforementioned things.
Did Mr. Santiago Cano go into custody soon after the incident? So he's been in for a year and 9 months, or was he not taken into custody until around the time of, well, I can see here. So the jail commitment was in October of last year. So this was not a situation that the allegations, the home invasion, et cetera, from December of 2020, that didn't result in an immediate arrest.
That's correct, Your Honor.
Okay. Do you know why there was an arrest in October of 2021 as opposed to December of 20? That's a passage of almost a year. It wasn't a direct indictment, and that's why he was arrested. He was arrested first and then indicted. So he was arrested on a warrant that some law enforcement agency took out.
That's correct, Your Honor. It was a transfer from Clayton County to a warrant in Fulton that was sworn out. What I can see in the discovery, Judge, and again, I'm looking through this morning, but from what I can see in the discovery, it looks like this arrest warrant was done pursuant to a photo lineup and was sworn out based on that. And then he was transferred in from Clayton County based on that. And that photo lineup occurred. I just saw it. Looks like the arrest warrant was taken out in December. Yeah.
Yeah, the day of the incident. Okay.
Although I have no idea. Yeah, the photo lineup was also done in December of 2020. Looks like the warrant was sworn out. Why there was a delay in the execution of the warrant, I do not know, Your Honor.
Okay.
I don't want to make up facts I don't have.
No. That's fine. I just was curious. I'm looking at the warrant as well. All right. Let me please hear from Ms. Jackson. Happy Friday morning to you. Do you have any criminal history information for Mr. Santiago Cano?
Good morning, Your Honor. We didn't receive this calendar, but I was listening. I just ran the record for you. The defendant does have 11 cycles. The defendant's last arrest was August the 30th, 2021 for simple battery, robbery, and terroristic threats, and that was in Clayton County, Georgia. There's no disposition for that arrest. The defendant did receive first offender treatment in 2013 out of Clayton County for felony obstruction of an officer. And the defendant does have misdemeanor convictions and sentences. one in 2016 for giving false information to an officer and driving without a valid license. And the defendant received a nolo contendere sentence in 2014 for theft by shoplifting. And there was a misdemeanor conviction in 2013 for driving without a valid license. Let me scroll up and see if there's anything else, Your Honor. Nothing in addition, Your Honor.
Well, thank you for reacting on the fly to this one. Question about the August 21 arrest. So it was arrest in Clayton County, sounds like for a couple felonies, robbery and terroristic threats, and one misdemeanor. What the GCIC is showing you is simply that Mr. Santiago Cano was arrested. It doesn't tell you anything more about that.
No, it was just an arrest.
Okay. All right. Thank you so much. Ms. Charles.
Yes, Your Honor. Your Honor, the state at this time will oppose the motion for bond, given the severity of the charges against Mr. Cano. This current no bond status, the state portions reflects the severity of the charges. Mr. Cano, during the incident with Mr. Castillo, one of the things that he's alleged to have done is after the incident inside of the house, Mr. Cano then drove past the apartment and shot up the apartment from the outside indiscriminately, notwithstanding any other innocent, residents of the apartment complex who could have been hit by a stray bullet. We note that he doesn't currently have a conviction from Clayton County, but the charges also reflect a sort of potential for violence. And we believe that notwithstanding his significant ties to the community, he does pose a risk to reoffend. And we believe that at this time, no bond posture should be maintained as it was maintained in the last hearing.
Your Honor, may I respond?
You can, not yet. I've got a couple questions, but you may. So, Ms. Charles, have you had a chance to look at medical records? The warrant says that Mr. Santiago Cano actually shot Mr. Castillo. He got hit.
He got hit in the leg.
So it wasn't I'm firing in the air, but
no, there was an incident inside of the house where he hit, then they left and came back, and then there was a drive-by shooting. So it's two separate incidences.
Okay.
We do not yet have medical records. They were requested at the intake and indictment process. That is still outstanding here. I will say this, Your Honor, in full transparency, the victim, Mr. Castillo, I have not been able to make meaningful contact with him because he himself is incarcerated.
He's in custody.
Yes, Your Honor.
Okay. That was my next question, which is, what does Victor Castillo say about Mr. Santiago Cano being out on bond?
He's upset as to what happened. He feels that he shouldn't have been shot. There was no need for that to happen. Obviously, it was quite severe.
Sure.
However, as far as him being out on bond, he didn't really have a position one way or the other. Looking at the co-defendant, there was a bond granted in the co-defendant's case. And so sort of on principle, based on the charges, we would oppose bond. If Your Honor was inclined to give bond, given the fact that the victim himself is incarcerated, we would ask for the conditions of a bond to reflect the same as the co-defendants, which was 100,000 straight bond with an ankle monitor, 24-hour curfew, stay away from the residents, stay away from the victim, which is fine because he's going to be incarcerated, looks like, for the next 5 years.
Mr. Victor Castillo, is not at our county jail.
No, he is in Burse Correctional.
Okay. He's in the State Department of Corrections.
Yes, sir.
Okay. So he is out of direct harm's way from either defendant in this case.
Correct.
Okay. And Victor Castillo, in fact, is Jessica Castillo's husband?
They were sort of legally separated,
okay.
Soon to be ex-husband.
Okay. And do you know what the warrant says is that Mr. Victor Castillo picked Mr. Santiago Cano out of a lineup?
That is correct. So he went during the initial conversation with officers. He said he knew Mr. Cano by a nickname. Officers then went and did an online search of Facebook found a photo of a profile of someone with that nickname on that handle, took a photo, and then showed it to Mr. Castillo, who said, yes, that's the person I know as Sweetie, and who was later identified.
Sweetie?
That's what's
Okay.
the nickname he said he knew him as.
So it's not a standard photo lineup of 6 pictures. It was a confirmatory, hey, you've been talking about Sweetie.
Mhm.
Is this Sweetie?
And he said, yes, that's
Okay.
who I know to be Sweetie. And he knew his ex-wife, Jessica.
Okay. All right. Ms. Hingerty, what did you want to add?
I just wanted to add, Your Honor, that I'm not in possession of any information about a subsequent drive-by shooting or anyone indiscriminately shooting into the apartment complex. That's certainly not a part of the state's discovery or the indictment. So
It's it's on the police report.
Okay. Ms. Charles is saying it's in the police report. So,
Your Honor, I saw where, the allegation took place at the front door of the alleged victim's home, who I'm just learning this morning is now in custody for 5 years. But if he's in the Georgia Department of Corrections, I imagine the state could have him produced.
Yes, the last time the police report says both Mrs. Sweetie and Jessica returned a short time later and fired 2 more rounds through the door. And then Mr. Castillo called the police.
So again, I don't see an indiscriminate shooting randomly into the apartment complex.
Well, if you're shooting from the outside.
okay, we don't need to go back and forth on that. Someone firing a gun's got some issues. I don't care whether it's indiscriminate or not. Someone got shot in this case. So this is serious stuff. This is not a love triangle and someone shoves someone else. It has been escalated to deep into felony territory based on the allegations. But I just wanted to understand the allegations. It was a little confusing because we had husband and wife, and in theory, the state's theory, wife is the perpetrator against husband. And I get it. These things could happen, especially if they're estranged, then it's not so much, it's less complicated. Did you want to add other things, Ms. Hingerty? I am not particularly focused on, was there an indiscriminate shooting into the apartment?
I wanted to clear up that I didn't really see that. I know this is not an argument about the facts of the case. But I wanted to confirm with pretrial is insofar as the information that I have, I understand about the Clayton County allegations, but I don't believe Mr. Santiago Cano has ever been convicted of a felony in the past. I do see some misdemeanor convictions that are pretty old.
So I heard pretrial say that Mr. Santiago Cano had a first offender felony, but he successfully completed it. So technically, you are correct. He has no felony convictions. If we were to think through, has he ever been charged with a felony and had to deal with it? The answer is yes, he has, but he availed himself of first offender status in 2013 in Clayton County.
Thank you. I just wanted to make sure that I heard that correctly. And that's we would just submit, ask for a bond, reasonable. Obviously, we're not concerned about contact with the victim at this point, and he would submit to an ankle monitor. If Your Honor was inclined to put him on a curfew, we would just allow that you allow him to work so that he could support all of his dependents, the children.
Okay, I understand. Mr. Santiago Cano, I learned through your lawyer that you had work-related injury. I don't know how long ago it was, but it happened. Yes. And there's a workers' comp litigation going forward. Are you able to work? If you were out, could you work, or are you disabled?
Sir. Oh, yes, sir. They said they can find me a job through the law firm working with to sue the company I'm going through. They said they can find me a job going through them, but just a step for me to go out and be free. I mean, that's the only thing I need to go, so I can just contact with them. They'll give me paperwork. They're gonna get me to any work companies that I can go work with, and that's the only thing I need, sir.
Okay, but you are able to work.
Yes, sir.
All right. Okay. Let me look at one other thing. Ms. Hingerty, are you willing to share with me what your client's connection or relationship is with the co-defendant?
Your Honor, my understanding is that the state's allegation is that they were in some way dating, but that is not my understanding of the actual truth of the case from my client. So I'm going to let them prove that, Judge.
Okay. I don't know that they need to prove it. That may be part of their theory. I don't think it's an element of any of the crimes, but I just was curious what you were in a position to disclose. It doesn't change a whole lot of what I'm doing. I just was trying to figure out why they would have been together in this situation if they were in fact together in this situation.
It's our position that if they were together, Judge, that she had reached out to him. So not that they were in any way romantically linked.
Got it.
In other words, I don't believe there's any sort of a no contact order that's needed there, but you know, they are co-defendants, so at the court's discretion.
Okay. There's already a no contact order in Ms. Castillo's bonds, what I'm looking at. She must have no contact with your client.
That's not an issue, Your Honor.
Where would your client live if he got out?
Back at the 948 Cone Road address in Forest Park, 30297. Is that correct, Javier?
Yes, sir. Yes, ma'am.
And
Been there for 4 years.
what's there?
His wife and his minor children.
Okay, so the kid, his 4 kids and the 2 step kids and his wife, they're all at that address.
That's correct.
Okay.
Is that correct, Javier? Yes?
Yes, sir. And yes,
That's what
ma'am.
I had written down. I wanted to make sure I was right.
Ms. Charles, in terms of discovery, where are you in thinking that you've got everything so you can provide it to the 2 defense attorneys?
I believe we have everything, and I think everything has been sent. However, I will go ahead and make sure that an evidence.com link is sent over again to supplement the initial discovery, and that should be complete. There's nothing else that I'm aware of.
So medical records, you have medical records and you've provided them.
Short of the medical records, Your Honor, short of the
Okay.
medical records.
Yeah,
But the CAD and everything else, yes.
and this showing I guess that's how you know, if you're able to say they got a photo off of Facebook and you are looking at something that is in what you believe was discovery you provided to both defendants.
Officer's report, yes.
Pardon me?
In the investigative report, yes.
Okay, but medical records you don't have yet.
Yes, I will double check with that. I know I see a note that had been requested, and I'll just follow up to see that it was received and share it with defense.
Okay. All right. Do you know, Ms. Hingerty, the status of this August 21 arrest? I know the status, he was arrested, but is there a pending open?
Judge, it remains open as my understanding, and he was granted and made bond on that case and then was transferred over to Fulton and has been sitting and waiting for the bond hearing in this case.
Okay.
So it is not a conviction, Your Honor.
That may be, it was when Mr. Santiago Cano made bond in this newest Clayton case. The warrant was already in place for this case, and so he would have gone from Clayton to here.
That's right.
Okay.
He was not aware, I don't believe, of the Fulton County warrant. I think he discovered it when he was booked into Clayton.
Do you have any information on that, Ms. Charles? Whether the investigators had, for example, reached out to either of the defendants saying, hey, we'd like to talk to you, and they did not connect?
No, Your Honor, I don't.
Okay. All right. Anything you want to add, sir?
Yes, sir. I just want to say, if you can give me a bond, sir, start back on my family. I want to be.
Hold those still while you're talking.
I'm sorry.
That's okay.
I just want to be back there to protect and, provide for my family. She's struggling out there. You can see behind me right now. She's crying. I never met her put through the pain that I put her through. especially my daughter. She's only 2 months and my still kids. And my kids too. I really want to be out there with my family. Income monitor, I pay for anything. I just want to be there for providing for her and for the kids. She can't be, I don't want her to be strong out there, sir. I really don't. And that's more a man job I got to do for me and step up. I'm not stepped up. And I apologize. I'm just trying to go back with my family and just provide for her. Put her through the struggle. She struggled for me on through a lot of stuff. I'm gonna just want to be out there with her. Just give me one more chance, sir. I'll prove to you. I'll prove to you. I'll be.
You don't have to prove anything to me. I need to make sure we're keeping folks safe and you out of trouble,
Yes, sir.
etc.
And I will, sir.
But I don't.
I'll prove.
But we'll see what happens.
Yes, sir.
All right. As a side note, Ms. Castillo's bond actually doesn't cover her charges. She got a bond when this was a CP case on armed robbery and aggravated assault. So she has a number of counts for which she has no bond. We'll need to fix that. So she'll need to come to court and we'll need to work through that. And she will have to go back into custody briefly just to be processed. And we'll figure that out. All right, Mr. Santiago Cano, I'll tell you, of concern to me is the fact that you heard that description from Ms. Jackson about how many cycles you have. I mean, you've been arrested a bunch of times. Sounds like you got some misdemeanors. As Ms. Hingerty has pointed out, you don't have a felony conviction yet because a case 9 years ago in Clayton ended up being first offender, but you got something new coming out of Clayton from August. And then you've got this, which is by far the most serious situation. So I do have some concerns about your ability to stay out of trouble. I'm less concerned about your risk of flight, which is what I'm supposed to be focused on most of all, where you come back to court. But I'm going to set a pretty stiff bond here because there needs to be a fair amount on the line for you to come on back. Let me get all the counts. So I'm going to set a bond that is $12,500 per count, which is a $200,000 bond. You will be required to wear an ankle monitor. You will have a curfew that requires you to be at home. And we can adjust this depending on your work schedule, but it's going to require you to be at home between the hours of 8 p.m. and 7 a.m. Now, if the work you get is in the evening, we can flip that around, but you don't need to be out and about after 8 p.m. And before 7 a.m. The only exception to that would be if there's a medical emergency. If you got to go to the hospital at midnight, you got to go to the hospital for you or someone you're caring for. You'll be required to reside at 948 Cone Road in Forest Park, 30297. You can have no contact with Jessica Castillo and no contact, obviously, with Victor Castillo. That should be easier because he's in the state system. But there's still ways to get word to people. And if Victor Castillo gets information to the state that shows you were getting word to Victor Castillo, your bond goes away. That's the easiest way to make your bond go away.
No, sir.
see if there was anything else, other bond. You'll need to stay, you know what, I'm going to change the way the curfew works. So you're going to have a full-time curfew, 24-hour curfew, until you get a job. And so the only reason to leave the Cone address will be to try to get a job or to have that job, medical appointment, or come into court.
Okay. So
Obviously, you need to come here if that's what's going on. I recognize that there's a high bond. If that is a bond that you cannot make, and this case is bogging down because the state isn't moving it along, then we should talk about this situation again. But if the state is moving the case forward, they get those medical records, the state's ready for trial when it's time. This is a bond that I think reflects the severity of the allegations, as well as what's going on in your life right now. We've got that open case from Clayton County with some serious charges as well. Ms. Charles, any other conditions you'd want to see on the bond?
No, Your Honor, that's sufficient, I believe.
Ms. Hingerty, any questions or anything you want to add to the bond?
No, Your Honor, but I just wanted to nothing to add, just a clarification question. So counts 1, 2, 3, 5, 6, 7, 8, and 9 each carry a $12,500 bond. Is that correct?
I think so. I'm not.
100,000?
So I may have done the math wrong. Whoops, that's the wrong app.
I just want to.
Yeah, I did the math wrong. So no, it's 25,000 per count. I want it to be a $200,000 bond. And so it's 25,000 per count. And that gets us to the figure that I stated.
Thank you. I was just confused there.
You should have been, because I did bad math.
Went to law school, so we didn't have to do math, Your Honor.
Yep, exactly. I'll call up the calculator next time. So we're clear on the record. It's 25,000 per count for a total good bond of $200,000, including an ankle monitor, the 24-hour curfew, unless Mr. Santiago Cano is looking for work, he's secured work, and then medical appointments and coming to court.
Last question, Judge, if you would. Is
Yes.
this a Fulton County provided ankle monitor, or are you expecting him to provide the expense for that?
So what your client told me is he'll pay for the ankle monitor. So that's how I think it's going to start. If that's not something that ends up working, we can revisit that. But you're the one who suggested the ankle monitor, and Mr. Santiago Cano is the one who said, I'll pay for it. So I don't think the county ought to pay for it at this point.
I understand, Judge. I just want to make sure that I get all of your rulings correct.
Yep, I appreciate you asking. Ms. Charles, anything else?
No, Your Honor.
Okay. So I'll sign that bond order soon. You'll see what you can do. Like I said, if that is a dollar amount that is not reasonable, then your lawyers will let me know. If the case is moving slowly, we'll do something about that. It doesn't sound like it needs to move particularly slowly. We'll just see if the state can get those medical records. And let me see if there is a So I don't have a arraignment or waiver of arraignment in this case. So why don't we take care of that as well? Because there's not a scheduling order in the case.
Of course.
I don't know how that slipped through.
We'll waive formal arraignment and reading, ask for an additional 10 days to file motions after we receive all discovery, Judge, and enter a formal plea of not guilty to all the charges accused in the indictment.
Okay, you'll get that. Actually, I'll issue a scheduling order soon that will give the state a deadline for providing the remaining discovery and a deadline for you to file any evidentiary motions that is after that discovery deadline. So that'll govern the progress of the case.
Thank you, Your Honor.
All right, Thanks, everyone.
I appreciate it. May we be excused, Judge?
Yes,
Have a wonderful day. Good to see you.
well, you bet. Welcome aboard, new attorney.
Thank you.
Read him up right, Judge.
Right, so this was meant, so I didn't get this, but this just says bond. It doesn't say arraignment. Okay, he was. Good. All right. So now he's been arraigned. We need to get Castillo back in here. I mean, it's not your job. We need to get her on a calendar. We'll do that. All right. Any luck with the Virgin Islands?
It looks like they're on, Judge.
They're
Wow, that's amazing.
Morning.
Morning.
Morning,
All right. I also don't have a calendar for this. Okay, let me find your email.
Are you standing in for Lauren? Are you standing in for Lauren McCauley?
No, she should
Okay.
be here.
Here, I can forward you the email just so you'll see.
Okay.
Can you just give me a case number?
Here's the 94672.
Here you go. Okay. It's a really short motion. Yeah.
Yep.
Yeah, it's like, it should be short.
Hold up. I don't.
Okay.
All right, Mr. Prentice, can you hear me?
Yes, sir. Good morning, sir.
Good morning. I'm Judge McBurney. I'm here in Atlanta. You are in the Virgin Islands.
Yes, sir.
What time is it there?
10:49, sir.
All right, same time zone. And where are you specifically? Are you in a jail or a prison in the Virgin Islands? Are you at home? Are you in your living room?
In prison.
Why are you in prison in the Virgin Islands?
Me around May 19, I don't the marshal here on the St. Croix keep harassing me, keep locking me up, sir, for no particular reason. I had to call the police like 3 times and call me more because it's a marked car keep sitting outside my apartment, and it's the marshal. Why is you keep harassing me? I don't get in trouble. I have a job. I will be my mother 24/7. My mother will pick me up to take me walk. My mother will pick me up to take me wherever I have to go. I don't check in on my daily, on my yearly check in. I don't miss probation. I don't miss the registry. So it's no way they could keep calling Atlanta and say I hear in the Virgin I'm messing up. It's a lie. It's harassment. I get beat up. The Department of Justice here in St. Croix beat me up, slammed me, almost killed me, and thought it was funny. My leg being swollen for like, for instance, my leg just went down. They slammed me in my leg and everybody, they were laughing. It wasn't funny. You almost killed me. You slammed me and you thought that was funny, and then you dragged me to the parking lot. And I tell you, my leg hurting. I went medical and my leg was swollen. My both legs were swollen. I asked them, why are you keep harassing me? I don't get in trouble. It's like, are you calling Atlanta and telling Atlanta, oh, Mr. Prentice down here doing bad? It's a lie. There's no way I could not provide no address. I don't put my people have to make sure I provide this address. I don't miss no probation. I don't miss the registry. So it's like every time I doing good, I get locked up for no reason.
Okay, I appreciate you sharing that. I'm sorry that you're having that experience down there.
Thanks for that, man.
I have a different impression of life down in the Virgin Islands, and it sounds like it's been real rough for you. And I appreciate you sharing that. I didn't mean to trigger that from you, but I did want to know how you were doing. So, Mr. Prentice, our hearing is going to be one that ought to go pretty well for you. There is a warrant for you here in Atlanta because there is an allegation that you violated your probation here in Atlanta. When that warrant was taken out, the prosecutor did not know that you had relocated to the Virgin Islands and that you were taking care of business down there. And consistent with what you just told me, you were registering and doing all the things you needed to do. And so what the prosecutor has asked me to do is to dismiss the probation warrant against you in Atlanta so that you don't have to be extradited back to Atlanta on something that, while important, isn't so serious that we ought to upset your situation down in the Virgin Islands. So I'm going to ask the prosecutor who has joined us virtually if she has anything she wants to add. I'm going to ask your lawyer. You've got a lawyer here in Atlanta representing your interests. That's Ms. Wood. She just waved at you.
Good morning, ma'am.
Good morning, Mr.
I'm going to hear
Prentice.
from her, and we may be able to take care of this real simply and then just not bother you anymore with what's going on in Georgia, okay?
Okay, sir. Thank you.
You're very, very welcome. Ms. McCauley, good morning.
Morning, Judge. Sorry for being late.
Not a problem. We had a long bond hearing, but we got through that. And I'm going to add you to the spotlight so Mr. Prentice can see you. What do you want to add, if anything, to what I just shared?
Nothing, Your Honor. I think I set it out in my motion pretty clearly that the violations, and just to make the record abundantly clear, Mr. Prentice has 3 issues. One, he has a probation violation warrant in the 19 SC case, which is a non-complex case that I would be asking this court to handle as well, because for the same issues raised in the 10 SC case that he also has a probation violation warrant on. There is also a outstanding failure to register as a sex offender warrant that was issued by the sheriff's office. And so just so Mr. Prentice can hear this, I have already let your attorney in the Virgin Islands know, as well as Ms. Woods, that we are going to ask for that sex offender registry warrant to be recalled for the same reasons as set out in the motion to set aside his probation warrant. Mr. Prentice relocated to the Virgin Islands. I'm a little unclear about whether or not that was communicated to the Department of Community Supervision, because I think that was actually communicated that he was moving to the Virgin Islands. And that was agreed upon that he was going to move to the Virgin Islands. And then he went and registered as a sex offender in the Virgin Islands. Whether he did it upon his arrival or shortly thereafter, he did register. And he has been compliant, has had no other violations, has had no arrests. And so it does not seem like a good use of our time and energy in our system, especially with the backlog and everything else that's going on, to bring Mr. Prentice back to deal with a technical violation that he is now compliant for and has had no other issues. So that's just what I would like to, so just so Mr. Prentice is aware, there is a third issue that we are dealing with that will be resolved that will not cause his extradition back to the United States or back to Georgia. The other thing I learned from speaking with his counsel down in the Virgin Islands is that Mr. Prentice has actually been in custody for quite some time, probably more time than what he would have spent in Fulton County Jail had he been arrested on these technical violations in the Atlanta area. He's been in for over 60 days. So I think, for the purposes of the probation violations and the registry warrant, he has spent a considerable amount of time in custody and needs to be released.
Got it. Okay. And I have the authority to dismiss the 2 warrants, 10 SC and 19 SC. You, Ms. McCauley, are working with the sheriff to get that 3rd warrant withdrawn or dismissed.
Correct. I'm actually asking them to recall it through GCIC.
Okay. Whatever the right verb is. Got it. Ms. Wood, is there anything you want to add from the Atlanta end of things?
Briefly, Judge. I just want to, on the record, thank Ms. McCauley for bringing this all together. I do have documentation, like she said, that he's updated everything in the Virgin Islands. I believe his mother's on the call as well. Judge, his whole support system is there in the Virgin Islands. I have a stack of 10 letters of reference for him from ranging from family friends to coworkers at Pollo Tropical. He has his own apartment. He has a good job. He's eager to get back into society. And so we just ask that you go along with what Ms. McCauley has laid out.
And I thank Ms. McCauley as well. Is it your understanding that Mr. Prentice is in custody in the Virgin Islands because of any of our warrants, or it's more along the lines of what he shared with us at the beginning with the harassment and he and the police, they're not friends?
Judge, I understand that they don't have a version of Rice Street there. So I believe that's why he was picked up there obviously because of these warrants. I don't think he has any pending cases there that I know of. So I think this is strictly from this.
So there is an urgency to what we're doing because it's your understanding, Ms. Wood, that once the 3 warrants are recalled or vaporized or whatever we're doing to them, then Mr. Prentice ought to be released from custody in the Virgin Islands.
That's my understanding.
Okay. Mr. Prentice, are there other reasons you're in custody, or is it these Georgia warrants that are holding you as best you understand?
It's the Georgia warrants because they almost kicked my door in. Like my front door was like, I had like at least 25 Department of Justice in front of my door. Time I opened the door, like I was like I had a body in here or drugs in here. So my mother, I was scared. Cause it's like I opened the door and I said, "Mommy, you can pay me for work?" She's like, "Yeah, I'm coming out." So when I open the door back, I open the front door again. I see 15 marshal, police, everybody coming. I shut the door back. I was scared. So I was like, Mommy, you can't police. She like, no. So I call my grandmother and my fiance. They're like, I tell her, get up. Can we be home waiting for my mother to take me up? And they surround my house. They say, if you open the door, we're going to kick on the door. I was like, you can't do that. This is a private facility. It's a private apartment. So my mother tell me, go ahead and open the door. And I opened the door. And the way I opened the door, they pushed my fiance to the side. She have asthma. She had asthma attack outside. Yeah. So, and the way they coming in, they were done deep in my apartment, like 25 of them. So I was like, I reached for my cell phone and I was like, Mommy, when I reach for a cell phone, the man backs me. Department of Justice backs me. Bam. I was like, why you backs me? My mom on the phone. He just hit you. I said, Mommy, this man backs me for no reason. So I get up to like reach for the phone again and the man drag me and grab me. And when I get outside is where everything happened. They slammed me, roughed me up. He almost scared me.
I got you now. Now we're going back to where you started. And I appreciate you sharing that again. And I've now connected it. That's okay. So the 15 to 25 Department of Justice guys were there. It's a lot of them because of these warrants. And we're going to clear up these warrants. As much as you might want to come visit Atlanta, you're not going to need to do that. You can do it on your own terms. I will take care of the probation warrants in the 10 SC and the 19 SC case. And Ms. McCauley will get the sheriff's office to recall the failure to register warrant because you don't need to register here. You don't live here anymore. You live in St. Croix. So you should be all set. Ms. Wood, what do we do? Let's say Ms. McCauley follows through, I follow through. How does that information get down to the Virgin Islands?
His attorney there has been very proactive in this case. So I'm going to follow up with him after this hearing, just so he can alert me if there's any other issues.
You've got a point of contact there. If you get in your hands, look, warrants were obliterated, whatever we're doing to them, you can give it to that lawyer who then hopefully could get a judge to release. Do they call them judges in the Virgin Islands?
Yeah. Yes,
get a judge to get Mr. Prentice out.
Yes, Judge.
So, Judge, there's one other step that we need to take is we need to include Ms. Bucks from the Department of Community Supervision with the orders setting them aside because they have to do something with their ICAC agreement of transporting him back to the U.S. So she just asked to be notified. I will forward that email address to Ms. Nelson.
Okay.
She has to receive all the paperwork as well.
Got it. And that's smart because that's another channel through which some of the information needs to flow. So my limited role will be to sign something saying probation warrants go away. Ms. Nelson will get that to DCS, who will push it through. We'll get everything to Ms. Wood that says all 3 warrants are dealt with. She'll get that to Mr. Prentice's lawyer in the Virgin Islands, and hopefully he can do what needs to be done. Mr. Prentice, do you have any questions for me or for Ms. Wood?
Yeah. Morning again, sir and ma'am. I just want to understand if a gentleman like myself is trying so hard and struggling, I lose 2 brothers. Why here in the Virgin Islands, the marshal find it so funny to keep harassing me, to keep locking me up and then calling Atlanta and say, yeah, he doing bad. That's all I want to ask you this morning. Like, it don't matter. It don't matter. Like, one thing I won't do, and I came from Atlanta doing this, sir. I won't miss a registry. No, sir. I won't miss a probation. I don't do that. Atlanta is very strict. So I came home with my mind frame like, okay, I can't miss no signing. I can't miss probation. Atlanta is different from home. If you miss a probation in Atlanta, you better call and tell them, this happened. Oh, you get signing, you better call. So I came home and I did what I was supposed to do. And they just like, I don't know, man, sir, but sir, ma'am, I just want outside of if they could just please stop harassing me down in the budget so I could live.
So, Mr. Prentice, it's a fair question. Our ability to control what these Department of Justice people do down in Virgin Islands is very limited. We can help make sure that the sheriff from Fulton County or the police from Atlanta are leaving you alone. But your lawyer in the Virgin Islands is the right person to be sharing those concerns with. We'll clear up the paperwork that may have prompted those 15 to 25 people to bang on your door and come on in and bash you when you were trying to talk to your mom on the cell phone. And hopefully they'll go bother other people and not you. You can get back to working at Pollo Tropical and taking care of your family, okay?
Yeah, thank you, sir. Thank you, ma'am. Thank y'all.
Bye, Mr. Prentice.
All right.
Thank God for me, 'cause it's been a real hustle since I came to the board. And yeah, I didn't want to come home and come up. When my bigger brother passed away in 2019, I would like come home or not. 'Cause I was doing good in Atlanta. So I just came home. And when I came home, it was like harassment. I was like, I should stay in Atlanta. But I God bless you and thank you. Yeah.
We're going to try to get Atlanta out of your life so that you can get back to doing what you need to do. Okay.
Okay, sir. Thank you.
All right.
Bye,
Take
Mr.
care.
Prentice.
Thank you, Ms. McCauley, for bringing this to our attention.
Welcome. Thanks, Judge. Just
All right.
save the county a very expensive plane ticket.
Yeah, well, but it would have been a nice trip. And thank you to the Bureau of Corrections in Virgin Islands for creating this connection.
No problem. Thank you.
All right. Take care.
All right.
All right. Bye-bye. Well, that was an adventure.
The other case.
Ms. McCauley, she's got the 19 SC. We need the 19 SC case number.
I can get that for you, Ms. Nelson. It is 19 SC 169693. You're welcome.
You'll call Mr. Ford.
Yes, sir.
He's not going to be around anymore, but you can call.